Welcome, everyone. My name is Olga Tamush, and I'm an associate attorney at Winthrop & Weinstein. I'd like to welcome you to our webinar, Expect the Unexpected, How to Map Out, Manage, and Mitigate Risk in Your Construction Project. Today's presentation is geared at owners and is for general informational purposes that do not constitute legal advice. That being said, we're going to hear from 4 panelists who are all members of our litigation and construction real estate group and have extensive experience in real estate litigation. More information about each of our panelists can be found at Winthrop & Weinstein's website. We'll begin with John Holper today, who will cover pre-construction considerations, then move on to Sam Carmichael, who will give us a primer on dispute resolution options. Christina Rick-Lucas will discuss project administration documents, and we'll finish up with Peter Economo, who will tell us all about post-construction contracting issues. If any questions arise, please feel free to input these into the chat feature, and we will attempt to get these answered if time permits. If not, we'll be sure to reach out to you after today's presentation. Without further ado, I'll kick it over to John to get the conversation started. John, can you give us some insight as to what type of things an owner should be looking for when vetting a contractor?
Sure. Thank you, Olga. Hello, everyone. Thank you for joining this afternoon. I do want to touch on 3 specific areas today. Now, I could spend the whole day or this whole presentation or several hours talking about the pre-construction considerations. There's a lot of them, but there's a couple in particular, given my limited time, that I want to touch upon today. The first one will be things you should consider when vetting your contractor and/or a subcontractor. The second issue is price escalation and what you should be looking for when it comes to negotiating terms of price escalation. And then finally, I would like to talk for a few minutes about force majeure provisions. These seem to be kind of the heavy topics that I'm finding, especially after COVID. And one of the things that I really want to focus on when it comes to vetting a contractor is it is very important to find your right contractor. And when I say that, not all the time is the cheapest or low bidder the appropriate contractor for your particular project. You need to be looking at things before you decide who you're going to hire, such as, has this contractor done this type of work before? Do they have references? How much manpower can they provide to the project? Do they sub out all of the work, or do they self-perform some portion of the work? These are all critical issues to think about. Obviously, the financial capability of your contractor is critically important as well. Things when it comes to the performance of the project, do they have a safety program? And do they have bonding capacity? On a lot of projects, performance and payment bonds are required. And it is important to know up front, does this particular contractor have an existing relationship with a bonding company? Are they going to be able to get adequate bonding? And if not, you need to know that up front, as opposed to getting down the road, negotiating a contract, and then at that point finding out they can't get the requisite bonds. The other issue to think about is the form of the contract they use. In my practice, typically I'm dealing with the AIA forms. However, there are different forms that are out there. Does the contractor have a self-prepared form? If so, you'll need to look at that closely, because most of the times those are very much contractor oriented. Are they using the consensus documents, which are similar to the AIA documents? There are some slight differences between the two, but a lot of the key provisions in those contracts correlate with one another. The other thing I would always mention is, whether it's a AIA contract, a consensus document, or some other form, those are simply forms. And everything is, you're entitled to negotiate those terms. And there's always key provisions that need to be negotiated. So my recommendation to people is don't just accept the form agreement. For example, there's some limited indemnification language in the AIA forms. But from an owner's perspective, there is certain language that you want to get in the indemnification provisions to get around what Minnesota is known in Minnesota is the anti-indemnity language. And I won't take a lot of time on that, but basically Minnesota has a law that says one party cannot indemnify another party for that other party's own negligence. However, there are exceptions to that, but it's based upon having certain language in your agreement having to do with procuring insurance to cover their indemnity obligations. And that is critical because there's a lot of case law out there that says the courts will uphold the anti-indemnity statute if you don't have the right language in there. So again, kind of the takeaway from the contractor perspective is make sure you do your due diligence before you get down the road too far with a proposed contractor. Now, I also want to mention very briefly, as an owner, owners typically do not have contractual privity with subcontractors. That's between the subcontractor and the general contractor. However, owners do have in the AIA form agreements the right to know who the subcontractors are and the right to reasonably object to a particular subcontractor if there's a good faith basis for doing it. So the bottom line on this, while an owner may not be in privity with a subcontractor, it does have the right to weigh in and decide for itself if it is comfortable with a particular subcontractor. For example, I had a deal recently where the contractor proposed a certain framing subcontractor. They presented that to the owner as part of their disclosure requirements up front. And the owner said, no, we've dealt with this particular subcontractor in the past and we reasonably object to that. And without having paid attention to that, potentially the owner could have been stuck with a subcontractor that they know, that they don't necessarily or didn't necessarily have a good experience with. And instead of being stuck with that subcontractor, they were able to find a new subcontractor that was acceptable to the owner. The second issue I want to touch upon is price escalation. Now, this has really become a heavily discussed and negotiated issue, especially post-COVID, and given the various supply chain issues that the construction industry has been experiencing. Price escalation clauses can be used to protect both developers and contractors, both in terms of a fixed price contract and a cost plus contract. It basically protects the developer so long as you have some certainty built into this. The same is true for the contractor. What this is really about is shifting risk between an owner and a contractor. And, if when the contract is first signed and the schedule of values is put out there, and let's say the contractor is not going to order steel for 6 months, okay? But they put a value based upon what they understood the price to be at the time the contract and the schedule of values was prepared. And they go to order the steel 6 months later. Well, in today's world, we know that prices are escalating. And so how do you do that? How do you allocate the responsibility or the potential risk for those escalations. And the key here for coming up with a price escalation clause is to have a baseline starting point, which is typically the schedule of values. From an owner's perspective, having a ceiling price and a floor price. When it comes to the clauses themselves and what to include, one thing that I think owners need to be really aware of is that increased material costs and price escalation clauses should only include the actual increased cost of the material itself. It should not include things like overhead, profit, general conditions. This is simply a mechanism to deal with the actual increased cost of the material itself. So when you see a proposed price escalation clause from a contractor, I would recommend that you always push back to the extent that it includes anything other than the actual cost itself. Now, just to give you some background on why this is so important. Between April of 2020 and April of 21, input costs for construction increased 26.1%. Bid prices, however, only increased 5.2% in the same time frame. And so you can see the disconnect there. And obviously, you know, it's hard to predict what the prices are going to do on especially a long-term project. But again, this is about setting some expectations. It's about bringing some certainty to the extent possible. And it's about allocating risk between an owner and a contractor. Now, there's a couple examples that we have in our materials. And the first example is kind of a basic price escalation clause. And again, if you note, and maybe Olga, we can go to the next slide. If you note, this clearly lays out that only direct out-of-pocket costs for materials to be incurred are subject to this price escalation agreement. It specifically says that there will be no general conditions, general requirements costs, unless there's an extension of the contract time. Now, the other thing that you need to keep in mind with these clauses is that they should not apply unless the contractor is acting in conformance with its obligations under the contract and acting in a timely manner. And what I mean by that is if there is a cost escalation because the contractor failed to properly manage the project, or for example, failed to properly order materials in a timely manner, thereby resulting in a price escalation, that from an owner's perspective is not what these clauses are intended to cover. It is incumbent upon the contractors to act timely, to properly manage their projects, to properly and timely order materials, and to manage and timely manage their subcontractors. So the key here is it's similar to force majeure, and we're going to talk about that in just a minute. But the key is the contractors need to be acting timely and can't come back and claim a price escalation if they're not acting in a timely manner. The second example that we have is a little bit different. And in short, here's how this works. This provides that if there is a price escalation, and it's defined here as a volatile market condition, What this does is it says, look, at you contractor are going to be responsible for the first 10% of that price increase. Once that 10% threshold is met, then it says, owner, you're going to cover the next 5%. Okay. At that point, the other thing that this provision provides for, and it gives some certainty to owners, is it provides towards the end of the clause that the owner will only be responsible for X amount of total price increases. So for example, if you put in there that, look, at we owner will cover up to $200,000 of price increases cumulatively after you contractor cover the first 10%, then that gives some certainty up front when it comes to owners being able to assess what their potential exposure is throughout the project. Again, this clearly provides that overhead, profit, or in general conditions should not be included in calculating the thresholds. It is simply the amount of the increased material costs itself. So there's many variations on how to set these up. These are two of the ways that I have seen in my practice. And again, this is something that, pre-COVID, I was thinking the other day, I can't remember negotiating one of these pre-COVID. Post-COVID, seems like, well, it doesn't seem like it is. They're in every single contract. All right, let me turn to the last topic I want to cover today, which is force majeure clauses. Let me start out by saying a force majeure clause is intended to cover unforeseen or unavoidable delays in a project that are beyond the reasonable control of the contractor. These provisions, and I've got many examples of this, do not apply, like I mentioned with the price escalation, if a contractor fails to perform as required by the contract or fails to act in a timely manner, thereby causing delay in the project. For example, a contractor should not be able to come back to the owner and claim force majeure if it did not order materials in a timely manner, and that in turn results in a project delay. So if the contractor should have ordered a specific material in month 4 and waited till month 6, and then comes back and says to the owner, well, look at that, we've got long lead times and the delivery of the materials is going to be delayed by 6 weeks. Well, that's not the owner's issue. The issue is you contractor did not perform in a timely manner and get the materials ordered in a timely manner. As such, that should not be the basis for either a price increase or an extension of time. Force majeure is an equitable right to extend the contract performance time due to specific events beyond the contractor's control, which were not caused by the contractor. Another example I've seen is a contractor fails to order permits in a timely manner. And they know up front, the permitting process for a particular permit, takes 3 weeks. And they wait too long to order the permit. And for example, the start date gets pushed back 3 weeks, longer than it should. It impacts the critical path schedule. It impacts the other trades and the scheduling and management of trades. And a contractor comes back and says, well, the permits are beyond our control. It takes too long. Again, no. If they act timely, that's one thing. But if a contractor is untimely in its performance, force majeure provisions are not intended to relieve them of their management and oversight on the project, because as people, I believe, know, contractors are responsible for their own means and methods, management, and scheduling on the project. Last example I've seen here in the last couple of years and fairly recently was the failure to schedule trades in a timely manner. A contractor will come in and say, well, I just found out from subcontractor X that they're not going to be able to start for X amount of weeks. Well, when did you contact them? When did you contractor first talk to them? Did you contractor let them know what the schedule was? And did you do so in a timely manner? If the answers to those questions are yes, that's one thing again. But if the answers to those questions are no, then force majeure clauses are not intended to shift that resulting impact on both schedule and or contract sum to the owner. So I would be, ask those questions when the contractor comes up with a claim for force majeure. The last couple of things I'll say on this is, number one, always have a notice in timing provision in your force majeure provisions. The last thing you want to see happen is a contractor recognizes a force majeure event, yet waits till the middle of the project, the end of the project to present it to you. Well, that doesn't do owners any good, because if they had known about it at the time of the event, then decisions could be made and can be made to either offset the additional costs or at least address the additional delay and cost. It's also important to have timing provisions in your force majeure clauses, because if the parties, the owner and the contractor, can't agree, in the AIA form documents, there are provisions that provide, if we can't agree on something, either party can submit a claim under the construction documents. The AIA documents also say that if a claim is submitted by either side, that the contractor and the owner will continue performing on the project and with respect to undisputed issues while the claim is addressed. So from an owner's perspective, you want to make sure that you have the right to assert that claim in a timely manner and not wait till the end of a project to deal with things. I have one example where a subcontractor claimed force majeure at the end of the project, never told the owner about it. The contractor never mentioned anything to the owner. The owner paid for this particular line item 100% of the scheduled value. And then at the end of the project, the subcontractor came back and claimed several $100,000 in both delay costs and requested, a very substantial extension of the substantial completion deadline. Well, if the owner had known about that up front, it could have addressed it then. Here, the owner was feeling like, we never heard about this. We paid the sub everything, and now they're coming back at the 11th hour and claiming all this delay, because the owner had delay claims both against the contractor and the subcontractor. So it is important to have some type of notice and timing. Typically, I'll see from within 7 days after the event is recognized by the contractor will provide notice to the owner, and then the owner has certain timeframes to respond. And if the parties cannot agree, then either side can pursue a claim, but the project should continue to keep moving forward and the parties should be continuing to honor their other obligations and responsibilities under the contract. So with that, like I said, I could talk all day on these and other issues, but given that we only have an hour, I appreciate you attending today, and I'll turn it back to Olga.
Thanks, John. That was super insightful. I know it's often tempting to just hire the least expensive contractor, and so it was a helpful reminder that that's not always the best idea. I also appreciated your discussion on force majeure clauses. It's the type of clause that can be so easily glossed over because it's just easy to assume it's standard language. But as you pointed out, it's important to go through it carefully and make sure it's not too broad and over-inclusive, especially in a state like Minnesota where we can and do expect cold weather and even the occasional snow emergency. So turning to our next section, Sam, can you give us a primer on what to expect when deciding on a type of dispute resolution process?
Sure, thanks, Olga. So no one wants to encounter problems during a development, but we do need to prepare for that possibility. And it's important to consider before we even enter into a development contract or a construction contract, how any problems that may arise will be handled. Typically, when people think of dispute resolution, they think of litigation, but this is just one avenue. And we're going to discuss three potential options: mediation, litigation, and arbitration. So before we dig into the meat of the dispute resolution options, I just want to mention that the AIA standard form contract, which a lot of developers and contractors use, requires that the project architect act as an initial decision maker on all disputes. We always recommend removing this provision because the architect's decision isn't binding and the parties never agree with the architect. Essentially, all this does is slow down the dispute resolution and further delay the project. Instead of this provision, we recommend inserting language requiring the parties to designate a representative who has power to reach an agreement. The provision should also state that the representatives have a certain amount of time, whether that be 15 days or 30 days, to negotiate a settlement in good faith. And if after that many days a settlement can't be reached, then the parties can move on to mediation, litigation, or arbitration. I'll briefly touch on mediation. Oftentimes in contracts, we require mediation prior to litigation or arbitration, and it can be beneficial and allow resolution to be reached quickly. However, it's also important to note that mediation is not binding unless and until the parties execute a settlement agreement. Prior to that, either party can decide that it no longer accepts the terms that were agreed upon during mediation, and there's no recourse for this. If it happens, or if an agreement isn't reached at mediation, then the dispute moves to litigation or arbitration. So first, I want to talk about litigation. This is what most people think of when they think of dispute resolution. Litigation is a really intense process that offers parties the opportunities to conduct discovery prior to bringing the case before a judge or a jury. As with everything, there are pros and cons to litigation. Benefits include the ability to conduct discovery, to really flesh out all of the facts underlying the dispute, and the right to an objective decision maker, whether that be a judge or a jury. Arguably, the biggest benefit is that litigation includes appeal rights. In essence, if a party disagrees with the outcome of the litigation, it can appeal that decision to the Court of Appeals, and the Court of Appeals will review and make another decision. As we'll discuss later, this is not permitted with arbitration. Cons of litigation, on the other hand, include that it can be expensive and it doesn't offer a lot of flexibility. All litigation essentially follows the same path: initial pleadings, discovery, summary judgment, and ultimately trial. In addition, the parties don't get to select their decision maker. Up until trial, a judge will be randomly assigned to the case. The judge may or may not have any experience with construction or development of any kind. If the case does go to trial and it's a jury trial, the parties do have a little influence over the jury, but they don't get to hand select people that they want to make the decision. Finally, something to consider is that litigation is public. which means that anyone can view documents filed with the court, they can attend hearings, they can attend a trial. Depending on the specifics of the dispute and the development, this could be a pro or a con. So it's something to consider individually before you select a dispute resolution mechanism. And then moving to arbitration, I'll just make an initial note that non-lawyers tend to think of arbitration as a better dispute resolution process than litigation. In our opinion, this is not the case. Despite what a lot of people tend to believe, arbitration is not faster or less expensive than litigation. In fact, the arbitrator selection process can take a significant amount of time and delay dispute resolution. For example, I have a case right now that's going through arbitration, and it took the parties months to decide on an arbitrator. The time, if we had gone through litigation rather than arbitration, could have been spent conducting discovery, drafting pleadings, and moving the case forward rather than just spinning our wheels trying to select someone to decide the issues. Despite this, the ability to select a decision maker is one of the biggest benefits of arbitration. Selecting the decision maker or makers, depending on if you select an individual arbitrator or a panel, ensures that the decision maker really understands and has experience with the type of issue that the parties are facing. In our opinion, though, the cons of arbitration outweigh this one singular benefit. As I mentioned earlier, there are no appeal rights with arbitration. The decision of the arbitrator is binding on the parties, even if it's objectively wrong. Also, as I mentioned, arbitration is not less expensive than litigation. There are still filing fees like we would have in litigation. And in addition, these filing fees in some cases can be based on the amount of the claim, not necessarily the amount that can be proven. So if the dispute involves a claim of $1.5 million, the filing fee is going to be based on that, even if that claim can't be substantiated. In addition, unlike litigation, the parties are required to pay for the arbitrator's services and associated fees, whereas in litigation, you're not paying the judge. Here, you're paying the decision maker. And finally, the last note on this is that unlike litigation, arbitration proceedings are private. They're not open to the public. And again, depending on the dispute and the development, this can be a pro or a con. And then there are just a couple other things to consider before making your decision on what dispute resolution mechanism you want to include in your contract. First is that once the parties determine how they're going to decide the dispute, the question is where the decision will be made. And most, if not all, states require dispute resolutions to occur in the location where the project is venued. So if you're in outstate Minnesota constructing a project, your dispute's going to be heard in outstate Minnesota. Next, specifically related to arbitration, if the parties choose arbitration, they need to consider whether they want one dispute decision maker or if they want a panel. Whatever the parties decide, they should also consider whether the arbitrators need special qualifications. For example, should they have previous experience litigating construction and development disputes? Should they have experience with the particular type of development that is at issue here? Whether it be low-income housing or a medical facility, is that important to decide the issues that may arise? Finally, the parties should also decide which arbitration rules will be used. There are several options, each of which has their own pros and cons. And unfortunately, we don't have time to dig into the nitty-gritty of all of those today. But if you have questions, please feel free to reach out and we'd be more than happy to answer those.
Thanks, Sam. You're right that so many of us assume arbitration is the faster, easier approach to dispute resolution, and that's been true for a long time. But with the changing landscape of arbitration, it's starting to make sense to go back to our roots and try and resolve things in court. Still, the best way to handle disputes is to probably just not get into them in the first place. So Christina, what are some things we can do preventatively to avoid litigation And what types of issues have you seen during the life of a project that can lead to disputes?
Thanks, Olga. I'm going to talk a little bit about some issues that arise while the project is ongoing. I'm going to focus on 5 main issues that we see causing a lot of disputes on construction projects. The first, management oversight and transitions. The second, inadequate project documentation. The third, change orders and change directives. The fourth, lien waivers, and the fifth, cure notices. So starting with management oversight and transitions, one major issue on projects is poor management. We see poor management lead to disputes constantly. As the owner, it can be a challenge to have much influence over the management of the project other than selecting your contractor. But one thing that you can do is require that you have approval rights, an opportunity to vet the manager on your project. That's something that can be written into your contracts so that when the contractor selects a person that they want to manage your project, you can interview that person. You can see what their credentials are. Do they have experience with this type of project? Is this somebody that you're going to be comfortable working with? Working those sorts of approval rights into your agreement can help you to have a little more control over the person that's going to be running that project for you. Same with the subcontractors. John mentioned this earlier. While as an owner, you're not directly contracting with the subcontractors, you can have approval rights and do your own vetting of the subcontractors that are going to be used to ensure that you're comfortable with the entities, the persons that your contractor is selecting. And then another issue when it comes to management is institutional knowledge issues. When you have a big project that tends to go on for a long time, it's really common, especially in this industry, to have a fair amount of turnover. So the person who's managing your project when it starts, it's highly likely not going to be the person managing it when it's done. So what happens to all of the institutional knowledge that first manager had when he or she moves on? This is going to lead right into my next slide, which is something that you really want to think about. Inadequate project documentation creates a big problem for the institutional knowledge of the project. And one of the ways to really protect against this is through requiring your contractor to keep good documentation. We hear all the time, about the practicalities of being in the field and how hard it is to put things in writing, to keep notes of all the meetings that you have, etc. But when that's not done and there's a dispute down the road or questions arise about who gave direction to whom, you have no idea. You have no way of going back and figuring out what went on. It's really important to try to get all of that in writing. Daily reports are a really great tool to keep good documentation about what's happening on the project. That's something that you can require in your contract, that your contractor is going to keep daily reports. These can include everything, who was on site that day? What was the weather like? Were there any safety incidents? So you have a really good record of what happened on that project every single day. And down the road, if you have a subcontractor or the contractor making some claim about, like John mentioned, force majeure. Well, the weather was bad, or it was raining, or we couldn't get this done. You have something you can go back to and look at and verify. Actually, it looks like you only sent one person to the job site that day. That's what caused the delay. There wasn't even rain. It was 72 and sunny. That being able to know what was happening on the site every day is a really good way to head off those kinds of disputes. Regular status meetings are also really important to keep the owner informed about what's going on. A lot of owners in contractor agreements will require regular OAC meetings of the owner, architect, and contractor getting together, meeting on site, talking about what's going on. It's really important when you're doing that you're keeping minutes of those meetings. What was discussed? Were decisions made? If you have all of those meetings recorded, then you have a really good record of what was going on at the site and how things were getting decided. A lack of documentation is one of the biggest obstacles to resolution when disputes arise. And it's something I see over and over with so many clients. I understand that as a practical matter, it can be really hard to document everything that should be documented. But doing that on the front end will really help you head off issues on the back end. Moving ahead, change orders and change directives. Real quick, just let me explain the distinction. A change order is typically going to be a request for a change in the contract that's often initiated by the contractor. Either there's been a scope gap maybe, or something, has arisen on the site that they didn't foresee. And so they have to request a change in the contract for additional work. And usually it's going to be accompanied by a request for either additional time or additional money. It's not a change order until both parties agree. So a contractor will often submit a potential change order, a PCO, requesting the change that they want, and then the parties agree or don't or negotiate that change order. A change directive is a directive issued by the owner for additional work. That's something that the contractor is going to have to do, but there may not be an agreement up front about whether that additional work is going to also require an additional cost or additional time. These can cause disputes when they're not properly documented. Organization here is really important. It's not uncommon to have a contractor say that a change in the work was authorized by a verbal authorization on site, or, well, I got this email that said I should go ahead and do it. When there's not a good record and you're not keeping track of how those change orders are coming in, it's really easy to lose sight of what the project is costing, what's going on the site. Everything should be well organized. And one of the best ways to do that is to use some construction management software. Contractors typically will choose what software to use. Procore is a popular choice. That's a way that you can organize all of the change orders in there and require that if a change order is going to entitle a contractor to additional funds or additional time, they have to go through the formal process. An email is not going to cut it. They're not going to get paid for work that was supposedly authorized by an email. They have to go through this formal process. And then ensure that the owner has full access to that software so that the owner can keep on track, keep on top of what's in there. Transparency is really essential. Last, I also want to mention it's important to ensure that your contract includes a time frame for a contractor to submit a change order. John was mentioning earlier issues with contractors coming up at the end of a project and saying, well, there was a force majeure issue and we had a delay and now we want additional funds, or you should move the substantial completion deadline. Having a requirement in the contract that a change order must be submitted within so many days of an issue arising when the contractor becomes aware of it requires that they get those change orders, the potential change orders, submitted timely so that you don't have any surprises at the end of the project. The next slide, just want to mention a few things about lien waivers. Failure to get lien waivers can cause a whole lot of issues on the project. There's two types of lien waivers, typically a conditional or an unconditional. A conditional lien waiver basically says, I will waive my lien rights upon payment. An unconditional lien waiver says, I've received payment and therefore I have unconditionally waived my lien rights. It's a good idea to have the payment procedure in your contract require that these lien waivers get submitted. Typically, the best practice would be to have conditional lien waivers for future payments submitted with each pay application, and also unconditional waivers for past payments submitted with that pay application. And no pay application gets processed unless all those waivers are included. A lot of lenders will require this. It can cause delays in getting draws paid if contractors and subcontractors are not providing all of the waivers that they need to provide. Often you'll have a title company or a lender that is reviewing those pay apps and ensuring that all of that documentation is there. If not, we would recommend, as the owner, you have somebody appointed to be doing that review, ensuring that all of that documentation is there. Because if you're not getting your lien waivers, you can get some really nasty surprises on a contract, on a development, when a contractor shows up or a subcontractor shows up and says, hey, you owe me $200,000 because I supplied all these windows and I never got paid. So lien waivers, incredibly important to be sure that you're keeping really good track of those and you're getting them for every single dollar that's going out the door. Last, I want to mention cure notices. This is also something that tends to cause a whole lot of disputes, a lot of consternation on sites. Again, it's really easy, I think, for contractors to be giving verbal direction, or owners to give verbal direction to their contractor about issues that they're seeing. But that's usually not going to qualify as a cure notice pursuant to your contract. So most contracts have really specific provisions dictating how those cure notices need to be provided. Almost always it needs to be in writing. Sometimes there are delivery requirements. You have to send it by certified mail or by FedEx. So pay attention to those things and ensure that you are giving detailed notices when there are deficiencies that need to be cured, because that opportunity to cure is going to trigger other rights and remedies for you under the contract. Usually you cannot terminate a contract. You can't get rid of a subcontractor or a contractor until you've complied with all of the cure provisions. And being sure that you are very meticulous and have followed each and every one of those requirements before you do proceed to terminate or to declare that a contractor is in default is going to be really important going forward. Because if that contractor comes back and it turns out you didn't do it correctly, then you could end up not being entitled to the remedies that you should otherwise get. The contractor might be entitled to damages for an improper termination. So those are the types of things you really need to be thinking about. And I would say if you are considering terminating a contractor or a subcontractor, it's a good time to consult with your attorney and make sure that you're complying with all of those requirements.
Thank you, Christina. I really appreciated your note on the importance of institutional knowledge. I think the natural temptation for any owner or project manager is to just focus on getting the project to the finish line. But losing that institutional knowledge, and especially not keeping proper records, can clearly lead to lapses in information and result in post-construction contracting issues. So Peter, as a project is nearing the finish line, what are some of the issues that the parties need to keep in mind?
Thank you, Olga. Today I'll be discussing post-construction contracting issues. So like Olga said, these are issues that arise as the project is nearing and passing final completion. And I want to discuss some ways that as an owner, you can contract to protect against some of the issues that arise during this time frame. There are plenty of issues that can arise as the project is completed and as the warranty period begins to run. But today I want to talk about 3 hot button issues that we've seen come up numerous times, especially recently. The first issue is warranty issues. And when it comes to warranties, the gold standard is to get them in writing. You do not want to be banking on oral agreements or conversations at the job site or emails, hoping that your contractor is going to then abide by any warranties they may have made in those extra contractual conversations. So to accomplish that objective and get your warranties in writing, it's also important to have something called an integration clause. And as I go along here, John alluded to it earlier, the AIA functions as a template, and it has built-in provisions that contract for, or maybe sometimes they don't contract for, the items I'm going to discuss. But it's important to keep in mind that the AIA is just a template, and that as an owner, you should feel really encouraged to deviate from that depending on the circumstances of your project and the objectives you hope to accomplish. So when it comes to integration clauses, AIA section 1.12 protects against the contractor arguing that prior conversations, oral conversations, email conversations are somehow an enforceable component of the broader contract that is later signed by the parties. As an owner, it's important to include an integration clause to protect against that exact scenario. You don't want the contractor coming back to you and saying, listen, I thought we understood that I would be done by X date, but then the contract says something entirely different. In that scenario, if you have an integration clause, you can point to the contract and say, this is what we agreed upon and this is what we're going to follow. So it's important to have one of those as a owner. The AIA section 3.5 includes two broad warranties on the part of the contractor. The first warranty is that the materials used at the project are of good quality and new. And the second warranty is that the work performed by the contractor is going to be free from defects. The AIA template does exclude remedies for issues and defects that are not caused by the contractor or that result from normal wear and tear or usage of the owner. And those are really two important exceptions. Again, the AIA is a template, and as an owner, you should definitely feel like it's important to get more granular on warranty items. A few things to consider when it comes to warranties is first, the wear and tear exception is probably too broad, or it's going to expose an owner to some risk that the contractor is may try to evade liability by arguing that, you know, the materials I use, that's typical in the year that since I've completed, it's typical that they look that way or they perform that way. The contract excluded for that. So as an owner, consider whether you want to make that wear and tear exclusion a little bit more narrow and define or exclude certain materials or certain aspects of the project from it. Another important thing to consider is the characteristics and materials being used in the project. For example, if a project contains historic or reclaimed materials, an owner should consider using additional carve-outs in the warranties that adequately adjust for the characteristics of those materials. Obviously, they're not going to perform like a brand new material or a brand new product, so the contract should account for that. It's also important to include a requirement that the contractor provide proof of quality of the materials and equipment being used throughout the lifespan of the project. Again, as an owner, it's another way to hold the contractor accountable that the warranties are being followed and to provide the owner with additional notice if issues start to arise. When it comes to warranties, timing is also really critical. And AIA section 12.2.2 governs timing, and usually for commercial project, the warranty period is only 1 year. However, obviously the longer the warranty, the better for an owner. So if you feel like there's room to negotiate with a contractor for a longer warranty period, great. It doesn't happen very often, but the AIA will give you a 1 year default period. Some other timing items to consider. And this is probably the most important timing item. Owners want the contractor to agree that the 1 year warranty period commences on final completion rather than substantial completion. And the benefit of that is that if the warranty period commences on final completion, it reduces the possibility that you're wasting the warranty period essentially performing punch list items. So that's one really important timing consideration from the owner's perspective. It's also important to make sure that the defect notice provisions are clear. It's really helpful to draw out how notice must be given by the owner to the contractor of defects and in order to trigger the repair obligations on the part of the contractor. The AIA does not require that notice is in writing. However, it's a good idea for both the owner and the contractor to allow for written notice provisions because it just avoids a he said, she said situation and any other doubt that might be cast on whether a notice was valid. The AIA generally requires for repairs to be completed promptly or within a reasonable time. Obviously, these phrases and terms are a little bit vague and they may be open to interpretation. So it's a good idea for owners to have more defined notice and correction periods. For example, in the contract, defining it as 30 days, 60 days, or some other period that's acceptable to you. Finally, AIA section 12.3 gives the owner the option of accepting non-conforming work and instead reducing the contract sum proportionally for the work that's defective but accepted. This is something to consider as an owner, but there is an inherent risk if you do opt for this provision in that you may get into a dispute as to the value of the price reduction that should be applied to the item that is accepted. So if you elect to include this option, it's a good idea to clearly define the materials and items that might be subject to this exception and assign specific values as to the exact amount that will be reduced from the overall contract sum. The next important post-construction contracting issue is punch lists. And punch lists are generally governed by AIA section 9.8. Under the AIA, once you near substantial completion, the contractor then is obligated to prepare a comprehensive list of items to be completed or corrected prior to final payment. There are a few things to consider when it comes to punch lists. First and foremost, it's good, like I said earlier, for owners to have a warranty period begin after final completion rather than substantial completion. Because by that time, the punch list items should be complete or close to complete. And this means, once again, that you have less chance of the warranty period being wasted while repairs are being made. Another important consideration is to define notice requirements and the punch list process clearly. For example, one way to structure it is for the contractor first to provide a punch list within X days of substantial completion. And as an owner, you can define how many days that is. Then the owner has X days from the receipt of the initial punch list to create its own punch list. After that, the two punch lists, the owner punch list and the contractor punch list, are then combined to function as a final punch list. And if you structure the punch list process this way, it allows the owner to have more input and oversight as to what items are being included and make sure that nothing's being missed. Again, you can adjust the timing of the punch list issuance to be earlier or later in the project, depending on what your objectives are as the owner. You can opt for interim punch lists throughout the life of the project to more steadily monitor and correct items in need of repair. And in any process from the owner's perspective, it would be smart to include a requirement of a final walkthrough with both the contractor and the owner present. The final topic I'd like to discuss are rights and remedies when a breach of the construction contract does occur. So what happens when things do actually go wrong? And there's a whole host of rights and remedies issues that I could discuss, and I'd like to focus specifically on the issue of damages. AIA section 15.1.7 governs the available damages in the event of a breach. That section contains a mutual waiver of consequential damages related to the contract, including lost revenues, rents, business opportunities by the owner, personnel expenses, profits of the contractor, even when the contract is terminated. So waiving these available damages, it's nice because if for some reason the contractor alleges that the owner breached the contract, then the owner doesn't have to worry about the contractor trying to recover personnel expenses of keeping people on the job site longer than anticipated. However, this waiver can hamstring owners and present a disadvantage in that it takes away some of the added incentive of the contractor to abide by the contract. Consequential damages increase the amount of damages that are available to recover. Therefore, if the contractor knows that the owner has the option of recovering these types of damages, they might think twice before breaching the contract. The AIA does not preclude the assessment or recovery of something called liquidated damages. And liquidated damages are a contractually agreed upon estimate of an item that is otherwise intangible or hard to define in terms of losses. So these damages would be attributable to things like delays, lost business opportunities, etc. Things that don't have a clear value or purchase price. And liquidated damages, or the availability of the ability to recover liquidated damages, is an important tool for owners because, once again, it increases contractor accountability in abiding by the terms of the contract. So for that reason, it could be advisable to include a liquidated damages provision in your contract. But if you do elect to do so, you need to craft it very carefully. Owners should consider adding defined liquidated damages amount for the contractor breaches of timing requirements, substantial completion deadlines, and final completion deadlines. And consider whether it should be a one-time payment, a per day or per week payment, or something else. If you do elect to include a liquidated damages provision, it is important, it's critical to ensure that the penalty, that it's not viewed as a penalty. Rather, the amount attributed to the specific liquidated damages breach has to be proportionate to the breach itself. If the penalty is too large, it will be viewed as a penalty, and it's possible that a court could find that it's not enforceable or recoverable. Those are the three important post-construction contracting issues I wanted to discuss, and thank you for listening.
Thank you, Peter, and thank you everyone for attending. We are right at time, so we'll have to end it here, but we'll be sending the slides and a video recording of today's presentation to all those registered. We really appreciate you joining today and hope that you learned something new. If you have any questions, please don't hesitate to reach out to any of our panelists. We'd be more than happy to get those answered and to follow up with you. Have a great rest of your day. Thank you.